the next case on the docket, 116151, State versus Satchel.
May it please the court, Caroline Zuschuk of the Kansas Appellate Defender Office, here on behalf of Mr. Charles Satchel. If I may, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Mr. Satchel's case is here for 2 reasons, and the first is that the district court erred by admitting overly prejudicial propensity evidence, and the second reason is that the district court erred by sentencing him to both lifetime post-release and lifetime parole to be served simultaneously. Briefly, the facts for the viewers watching on the web. Mr. Satchel was convicted by a jury of multiple off-grid sex offenses and 1 on-grid sex offense. At trial, the state moved to admit evidence of a prior case in which he had been involved, where 3 people had accused him of sex offenses against children, and the case had ultimately resolved in pleas to non-sexual crimes, though there was a confession in that case to one of the allegations, though he alleged that confession was coerced. In this case, 2 different alleged victims came forward, and the district court permitted all 3 of the victims from the prior case, as well as the detective from the prior case, to testify. And then they also admitted his statements from the prior case, I believe the video of it. And then when the jury convicted him, he was sentenced to 200 years and 100 months prison, and also to both lifetime post-release and lifetime parole. The first issue is the one I plan to spend the majority of my time on, but I will attempt to get both within this narrow time frame. So under 6455D, propensity evidence is admissible in sex cases, and despite challenges by my colleagues, we have not been successful in finding that unconstitutional. However, in order for it to be constitutional, there are certain prophylactic measures that the district court needs to take as part of its function as a gatekeeper. And though those aren't explicitly laid out in the statute, this court has read into them the balancing test of prejudicial versus probative. And that test asks whether in order to make that determination, this court has adopted the Benally test, which was clearly enunciated in Bowen and laid out 7 factors to consider when making the decision. And those are how clearly the prior act has been proved, how probative the evidence is of the material fact, how seriously disputed the material fact is, whether the government can avail itself of any less prejudicial evidence, how likely the evidence will be to contribute to an improper verdict, the extent to which it'll distract the jury, and the time it'll take to prove it. And I think the problem in this case isn't propensity evidence probably could come in this case. However, it's the manner in which the propensity evidence came in that I think is the real problem. Based on my reading of the case law, once his proclivity to commit sex offenses was at issue since his defense was a complete denial. So we're probably looking at that, since his propensity was at issue, that material fact is in dispute. So my position isn't necessarily that the evidence can't come in, but rather that letting in 3 child victims, the detective, and a videotaped confession that he alleged was coerced was unduly prejudicial in this case.
Here's what I'm wrestling with exactly on this point, and it requires some precision,
Okay.
I think. It seems to me that you've got the gatekeeping function of 6455, and if I just heard you right, you're sort of saying, yeah, this stuff that the facts come in.
Correct.
Now we're talking about the volume of the facts coming in. And did you object on a cumulative basis? I mean, at some point, in your briefs, you're talking about, so many people came in and testified and all that, and you can balance whether it was necessary given that your client was disputing it. But let's set that aside for a second. If the argument really is too much of this came in, that seems to be to require an objection for the evidence being cumulative. And I didn't see any reference to that objection having been made and overruled. And it seems like if it was made and overruled, that's the error that we've got to think about, not whether just the gatekeeping decision was wrong because it turned out later a whole truckload of evidence that wasn't necessary came. You see what I'm saying?
I do, but I think that there's a distinction to be drawn. I think absolutely this potentially could have been raised in that manner that you're discussing, that there was a problem of cumulative evidence. I know I've raised that type of issue before where...
But it wasn't in this case, am I right
it
about
was
that?
not.
Okay.
No, there was no objection that there was cumulative evidence of the propensity.
But there was an objection based on the balance of probative versus prejudicial.
Exactly.
And certain of the factors that we've said need to be evaluated in that go to how much evidence and how it comes in. The method of presentation, not just the fact of presentation.
Exactly.
And how does the trial court know that at the gatekeeping point?
Well,
When you're at trial and your client's denying anything happened, and so who's to blame the state for trying to prove something that you say is not true?
Well, that's the point of the trial. So the state certainly isn't to blame for putting on its case. However, the gatekeeping function in this case is these 7 factors. And one of those factors is there less prejudicial evidence of propensity? So the court just here was like, well, propensity evidence is the only evidence of propensity, so there's no less prejudicial evidence. And if that were the test, then what's the point of having that as a factor? Rather, when we look at whether there is less prejudicial evidence the state could avail itself of propensity, we should look at, could the parties have submitted a stipulation that he was previously accused of sex offenses, confessed to one, and ultimately pled to non-sexual offenses?
How does that work when your client was denying that he committed? So you're just saying the plea itself, not the acts?
Well, certainly. If you look at the Bowen case, for example, where this court found that the evidence was not more prejudicial than probative, the court said the district court carefully controlled how the evidence was presented. It decided it would allow the state to admit only a journal entry. It considered the similarity of offenses and excluded victim and witness testimony, which it considered more prejudicial. Moreover, the presentation of the evidence was not time-consuming. It was admitted as a written stipulation given to the jury, together with an instruction cautioning the jury that a guilty verdict could not be based on the prior crime's evidence alone.
But this case doesn't fit that.
Why not?
Because you don't, in Bowen, you had, the only thing you were arguing about was the conviction for the crime. So you've got something easy to put into evidence that you can control. But your client's saying, this never happened. And so the state's got to come in and present evidence that it happened.
And on the face of the plea, there's nothing that would, by the names or the titles of the crimes of conviction under the plea, that would have indicated this is what happened.
Certainly. And I'm not suggesting, and I'm sorry if I wasn't clear, I'm not suggesting that the exact same thing would have been done in this case. I'm suggesting that the court should have engaged in the same sort of analysis and weighing of the factors. At the time of the gatekeeping function, if you look at volumes 9 of the record, the court asked the state, so what is it that you want to bring in this case? And they're like, well, the testimony of these 3 live victims, plus this, plus that, when in fact, there is less prejudicial evidence that the state could have availed itself of to prove propensity.
Ms. Zuschek, that's the point I want to stop you on.
Yeah.
Okay.
And just really clarify it.
Certainly.
Because clearly the factor is whether the government can obtain any less prejudicial evidence. But he's denying that any sex offense previously occurred with these other 3 alleged victims. So he's not going to stipulate to anything that says it did in fact occur. And whether that occurred is how the state is actually proving propensity. So I'm struggling with whether there is any less prejudicial way the state could have presented this testimony. Of the witnesses they presented, the only one I can see they could have left out was the polygraph examiner, because the detective or other officer who testified was also present when that occurred and heard the statement that was made that they wanted to use from him. But I'm not understanding how you would get away from the testimony of the 3 children, because he's not admitting it occurred, and whether it occurred is the central question in proving he has a propensity to do this.
Or could he, if I may?
Sure, absolutely.
Or could he stipulate, talking about getting very precise, could he stipulate that the state could have put on evidence to support that those crimes occurred? In the same way that somebody does when they do, maybe a no contest or whatever, where they say, I'm not admitting, but the state has evidence to support that these crimes occurred.
Well, Your Honor, that's exactly what I was envisioning when
I thought that
drafted
might be what
and
you meant.
and
Not just a mere stipulation to the earlier conviction.
right, because that wouldn't have established the propensity. However, there's certainly a way to draft a stipulation that says he was accused of these offenses. The witnesses, even a statement, the witnesses would have testified to this, rather than parading 3 more children in front of this jury.
So are you suggesting that the trial judge has an affirmative duty to say, okay, can we do this? Can we do that? Can we do this option? Instead of counsel coming forward and saying, Judge, we think there is another method for this that would be less prejudicial.
I am saying that the district court has an affirmative duty to look at the factors. And one of the factors is there less prejudicial evidence that the state could avail itself of? And simply saying, well, it's propensity evidence and this is propensity isn't fulfilling its duty under that particular factor. Would I have a stronger argument if counsel had said, well, while we're on that factor, I would submit that we could handle this in a different way? Certainly I would. But I don't think that it relieves the court of the duty to examine each of these factors. Propensity evidence is coming in sex cases, and in all of the other cases that this court has heard since the statute changed, allowing it in, there was not this situation where there were 5 witnesses with children victims retestifying about
Was there
things.
any explanation as to why this evidence is coming into the jury? I understand that the judge found that there was a limiting instruction was not required. What explanation was given to the jury about this evidence? Any?
No.
Okay.
And that's one of the other things that differentiates this case is to ensure the protections, like, for example, in Boysaw, the court was told you can't use the evidence of these.
In almost all these cases, there's some form of explanation through a limiting instruction or at least the introduction of the evidence as to why this evidence is being offered.
Here instead, they just basically retried a prior case that had resolved in a plea to non-sex crimes within this case, and doing so here was overly prejudicial. Even if there is a particular case under the wing of the factors where letting in prior victims might be the best option, or even a case where the defendant isn't willing to stipulate, I think the court has to at least examine that factor as well as all the other factors. For example, the first factor, that this wasn't clearly proven in a prior case. Yes, there were allegations, but we could have simply brought in there were previous allegations of inappropriate touching. Then also in terms of whether his touching of a 7-year-old girl over her bathing suit demonstrates a propensity to engage in this conduct is also sort of debatable. Some of the 3 prior victims, hers was probably the most dissimilar, and that wasn't even weighed or considered separately. So it's simply our position that the district court has a duty to engage in the balancing of these factors. Just because propensity evidence is admissible doesn't mean it's all admissible, or it's admissible in a big volume without even considering alternatives or questioning them. And I see that I'm out of time, so I will reserve the remainder for rebuttal unless there are any questions.
Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state. Before I get started, I do want to clarify one factual assertion that was just made by my colleague, and that was that the touching of the 7-year-old girl was over the bathing suit, and it was not. It was penetration of the child on more than one instance, and she did testify that he did touch her private part, and then the PC affidavit says that there was penetration, so this was not touching over the bathing suit. Now, I admit that the gender is different, but I just want to clarify that was not exactly the way the evidence played out.
Ms. Isherwood, right off the start, this troubled me when I read the briefs and read the explanation for the offering of the 6455 materials. And the prosecutor told the judge at the pretrial hearing that the state wanted to merge the facts of the cases together. So it is almost having both cases and the information from both cases presented to the jury. And isn't that the problem with 6455, especially in the absence of a limiting instruction, that there's really no distinction between what is being charged here, who the victims are, and bringing in these 3 other victims? I don't know how a jury sorts all that out.
Okay, well, couple things.
I mean, that's the motivation of the prosecutor, was to try these 2 things together.
I think we have to temper the comments of the prosecutor as far as what she's communicating, as far as I intend to present this evidence in the form of the testimony of the individuals that were victimized in the prior case as evidence in my instant case for my 6455, with some sort of sinister or nefarious intention to overly prejudice the jury with respect to the admission of the evidence. I don't think her intent was to pile on. So I would temper the language that she used. As far as a limiting instruction, this court has previously found that a limiting instruction is not required in propensity cases or in subsection D cases, because the whole purpose of a limiting instruction previously in 6455 cases was, hey, you can use it for A, B, C, and D, but you can't use it for propensity. Well, that doesn't really fly or isn't really conducive to this type of factual situation.
There's got to be some kind of limit out there, right? Ultimately, there's got to be some kind of limit out there, because otherwise you have people being convicted merely for having a propensity, whether they acted upon it or not. I mean, there is some outer limit, isn't there? And I think that's what we're struggling to find.
And I absolutely understand that. But I think what we're trying to do is place an onus on the district court at the time of admission, when all it has in front of it is the evidence that the prosecutor intends to admit. And so then if defense counsel has lost the 6455 case, then, or motion, then
Just
it is
to keep it out altogether.
right.
Yeah.
Then it is then on counsel to determine, how can I then mitigate, or how can I limit this? That is not the responsibility of the trial court.
I understand
the
there's
trial
a
court goes,
role issue on top of
Right.
all of the rest of it.
and I think when we get into the meat of this case, the rubric doesn't say, first of all, that this court has used, that there is a limitation on the way that the prosecution can admit the evidence. That's not there.
There's a factor, though, isn't there, among those 7 that deals with,
Whether the government can avail itself of any less prejudicial
that's one of them,
evidence.
but another one is how much time it's going to take. I mean,
Exactly. So let's look at this case.
Okay.
We had 5 witnesses that were brought in to testify with respect to this previous case. 5. Substantively, their testimony only took up 37 pages. So the prosecution did take measures to sanitize
You're talking about the 3, just the 3 children on
the
the
3
tape?
children and then the 2 law enforcement. So 5 witnesses total.
Okay, you're saying all 5 witnesses is 37 pages?
Yes.
Okay.
Substantively. That doesn't include what's your name, what's your occupation, that sort of thing.
Okay.
So when we look at AL, her testimony substantively, as far as exactly what the defendant perpetrated, was 3 pages. We didn't go into, did it hurt? Where were his fingers? How did it feel? Did you cry? So the state did take a very limited approach with respect to how this evidence was going to come in. It did not take the opportunity to pile on to make it as prejudicial as possible.
even if this court were to find that it was erroneous for the 6455 evidence to come in, the inquiry doesn't end there. The court then has to determine whether any error that occurred was it harmless, and that is whether there is a reasonable probability that the error did affect the outcome of the trial in light of the entire record. So can it be said that those 37 pages outweighed the strength of DS and ZS's statements throughout the course of the case, that it outweighed the statements of the defendant's girlfriend, Kylie Fogler, that the defendant told her, I had fantasies about these two boys in particular, and her statements that the defendant encouraged her to bring these two boys into their bedroom so that he could fondle them, and that on one occasion she observed the defendant leaving the bedroom with DS and they were both zipping up their pants, which we then learned was the initial touching between these two. And then does it also outweigh the fact that the defendant found a willing participant in his subsequent girlfriend, Jessica, to then utilize these boys during the course of the touching? And it would be the state's position that any error with respect to the admission of those 37 pages of testimony would be harmless in light of the entire record. If there are no further questions, the state would submit the second issue on the brief and respectfully request that the decisions of the Court of Appeals and the District Court and the defendant's convictions be affirmed.
Thank you, counsel.
May it please the court, briefly to touch on two things Ms. Isherwood mentioned. The first is I did misstate that he touched her over the bathing suit. He did touch her under the bathing suit, and I apologize for that misstatement. However, my reading of the record indicates it was a single occurrence, and it happened for approximately 10 seconds. So I think that perhaps there are so many witnesses, it does get confusing, and that's part of the problem with what happened in this case. The second thing about the limiting instruction for propensity evidence, true, the trial court found that no limiting instruction was required to say that you need not consider this as evidence of propensity. But in the other cases that we've been talking about, the limiting instruction given was a distinct limiting instruction saying you may consider this for evidence of propensity, however, you may not convict him solely based on propensity evidence alone. And I think that would have been an important prophylactic in this case, and perhaps I should have raised that additionally as a clear error issue. Nonetheless, I think that when we're talking about the balancing factors, this comes into play. And I guess I would just leave the court with a final question that my colleague stated that she thinks that the state made an effort not to pile on and make this as prejudicial as it could be. And while that may be true, I can't imagine how it could have been more prejudicial. And I would just leave the court with that. I think there has to be some limit with the 6455 evidence that we're admitting. Otherwise, we're risking convictions based on propensity evidence alone. And in this case, the volume, there were more victims from the prior case than victims in the present case. He didn't have a confession in the present case. He had one in the prior one, although to a dissimilar victim. I think these things deserved attention and weighing by the court, and that the failure of the court to do so resulted in harmful reversible error.
Do you agree that that our standard review here is abuse of discretion? Because we're reviewing the district court's weighing of probative versus prejudicial.
Yes and no. To the extent that we're weighing their to the extent that you're reviewing their weighing of the factors, that would be an abuse of discretion review. However, part of abuse of discretion review is whether they appropriately applied the law. And it's my opinion in this case, by dealing with the propensity factor, or by dealing with the more prejudicial evidence factor, by just saying, well, it's propensity evidence, there's no less prejudicial evidence of propensity, because it's propensity that they failed to exercise their discretion when weighing those factors. They didn't apply the right legal framework to their balance. Therefore, there is a de novo part of the review.
So you're relying on the prong of our abuse of discretion rubric that says the decisions based on an error of law.
Yeah. So
And the error of law is,
the misapplication of the factors, not actually failing to understand that that particular factor isn't whether there is less, isn't whether there's other. They basically said, well, they want to show propensity, and so therefore there's no other evidence of propensity other than propensity. But it's actually a more nuanced factor, as I believe this court has outlined in Bowen, Dern, Boysaw, Razak, where the question isn't propensity evidence is the only evidence of propensity, but what type of propensity evidence. And so I believe it was a legal error just to say propensity evidence
Comes
admitted.
in and it's.
Yeah.
so you're, and just final point, does that mean that you're not relying or you're not making the argument that no reasonable judge would adopt this court's view? In other words, if we disagree with your argument as a matter of law, does that mean that you lose?
No, I think then I would argue, of course,
You
that
want
no,
an alternative argument?
yes,
that-
no
Should
reasonable
have
person
plan
would
B.
agree, of course.
It's a
But
plan B.
I just wanted to clarify. I thought that would be your answer, but I wanted to make sure we got
I
that.
appreciate that you clarified that. Thank you. Thank you for your time.
Other questions? Counsel, I failed to do this on the prior case, but I would like to thank both of you for your cooperation and rescheduling from Monday with the inclement weather. I know in particular it was a burden here because Ms. Isherwood had already traveled to Topeka, so we are appreciative of that, and I just wanted to note that, so.
I would also like to thank Ms. Isherwood for agreeing to reschedule because I know it is a drive for her as well, and it was very appreciated. So thank you.
With that, the court will take this matter under advisement, and we